Is that subject to a First Amendment right of access? We haven't waived that argument. That's an argument that Kern says should be at the forefront of the court's analysis, regardless of which side is raising the issue. The court has to determine whether this hearing on the 17th is comparable to a trial or to a prelim. It's unique in the sense that it's focused solely on what everybody has to say is inadmissible evidence. Is that the type of procedure that there should be a compelling interest demonstrated? And in any event, we have demonstrated a compelling interest. Mr. Robinson's right to a fair trial by an impartial and representative jury. And that right, according to the U.S. Supreme Court, takes precedence over every other right. The press enterprise case that was cited about the efficacy of voir dire and the Algier case that was cited for the same proposition conflicts with Gentile versus Board of the State Bar, which was decided years after Press Enterprise 2. Press Enterprise 2 is decided in 86. Gentile's decided in 91. And if you look in the discussion in Algier about what cases are cited, when the court talks about the efficacy of voir dire, Gentile is nowhere mentioned. So the Supreme Court may have its own view. The Utah Supreme Court may have its own views about the efficacy of voir dire, but I would ask, how does one explore with a juror whether they have been exposed to publicity that is specifically prejudicial, things like a confession? Did you see any, have you read, you ask a juror, have you read or seen anything in the electronic media about this case? Not that I recall, is a typical answer, even if they've seen a lot. And then the next question was, when you attempt, can you or should you attempt to jog their memory by mentioning specific prejudicial information? Well, how about a confession? How about a statement by the President of the United States that Mr. Robinson should be executed? Have you seen anything like that? Now, that type of voir dire is designed to bring to the jury's attention the very information you don't want them to have. So, just throwing out the vague proposition that, voir dire, the traditional means of curing pretrial prejudice, doesn't deal with the realities of voir dire in a capital case where the prejudicial publicity is as extensive as this one. There is a discussion of this issue in an older case, but it always struck me as kind of really stating the truth of it. In the court, this is an old high publicity murder case, California case, Corona versus Superior Court, 24 Calab 3rd, 872. And the court is characterizing its experience with voir dire as an effective method. And the court says, questioning on voir dire as to the effect of the media's evidentiary disclosures, one prospective juror may deny or admit awareness, another disclaim or admit prejudgment. One may falsely deny both knowledge and prejudice for the sake of a place on the jury. An honest juror may admit knowledge or tentative prejudgment and find himself excluded. Many will sincerely try to set aside their preconceptions and give assurances of impartiality, yet unconsciously bend to the influence of initial impressions gained from the news media. And along the same lines, we have in this case an expert declaration that is discussed in docket 305, which talks about the importance of repetition in causing conscious and unconscious bias in jurors. And the importance of unconscious bias is it's by definition bias that cannot be weeded out by voir dire because the juror doesn't know they've been affected by it. And the expert, this is page 94, 305, says the volume of coverage in notorious cases can be overwhelming. And studies show that the quantity of pretrial publicity to which jurors are exposed affects their level of bias. Across studies extending back several decades, researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants when they are exposed to more publicity, both as a general conclusion, i.e. showing a general propensity to prejudgment based on an increase in the amount of exposure, and in response to specific thresholds, i.e. showing that prospective jurors exposed to at least 3 newspaper articles about a crime were more likely to believe there was ample evidence against the defendant. This effect has been demonstrated in both naturally occurring and controlled settings, confirming the validity of the proposition. And along the same lines, the U.S. Supreme Court, in a case cited on that same page, U.S. Department of Justice versus Reporters Committee for Freedom of the Press, 489 U.S. 749, says, the fact that an event is not wholly private does not mean that an individual has no interest in limiting disclosure or dissemination of that information. So the fact that there's already existing prejudicial pretrial publicity out there should not give rise to the conclusion that, oh, well, let's add some more. Because this court, at this stage of the process, still has the ability to control this process in a way that will protect Mr. Robinson's right to a fair and impartial jury by a representative jury. And just to say, well, we'll handle it down the road is to ignore the mandate of Maxwell that the court has to be proactive and to take action before the prejudice happens. So we're seeking to prevent future prejudice. It's already existing. There's no doubt about that. But to throw your hands up at this point, this early stage of the case, and say there's nothing I can do about it, we're just going to continue along the same lines, allow these people to keep making these prejudicial statements and hope for the best down the line, and that we won't have to exhaust the entire pool. We won't have to move for a change of venue. And again, there are costs associated with those remedies that we think argues in favor of this motion.
Thank you, Mr. Burt.
Thank you.
All right, I just have a couple of questions for the parties. The intent is to obtain these, and then the court will take a brief recess.
All right, as you see there, we're listening into this court hearing as the judge is now saying that they will take a few questions before heading to a brief recess. Let's go ahead and slide away, though, for a quick 2-minute commercial break. Stay right here with us.